and its management. And now, to address the legal concerns of our community, AM 1310 The Light presents Legally Speaking. Here is today's host.
Good morning. Good morning. Good morning to all our YouTube, Facebook, radio audience here in Indianapolis, around the country. Thank you for listening in today to our show. This week, we have, again, some of the most outstanding legal minds in the country, starting with the famous lawyer from LA, Milton Grimes, who led the way in terms of videotape evidence in the Rodney King case. Then we have John Sweeney, a well-known trial lawyer who developed widespread corruption in the LA Sheriff Department, became historic. And finally, our other anchor is Vanita Banks, one of the top cyber security experts in the country, which is just thrilled to have such outstanding guests. But today, the trial of the century is in progress. We're going to make some comments on this. That is the George Floyd murder that led to widespread rioting, civil unrest, and a reckoning in the United States of America. No one who saw the videotape of the murder was not touched by what they saw. We're now in the thralls of justice, and the issue is whether or not the police officer would be held accountable for his action. We've seen evidence presented, and what I was amazed about in this trial, the excerpts I was able to see, is how well the jurors were prepared. Then it made me realize that they've all seen those videotapes at least 20 times. So as lawyers, the one thing that we know is that when you present a case, if 10 people saw the same set of facts, they would have 10 different versions. This is the first time I've seen any trial where all the witnesses who were fact witnesses are saying the same thing. Now, having said that, we've been watching this, so we start off first with the historical perspective with Milton Grimes. We're going to talk very briefly about the Rodney King case, only because there's going to be parallel in terms of the defense. There were some cases that came about historically, and the defense obtained acquittal of a police officer using this age-old defense. Milton, tell us about that. What type of defense do you anticipate they're using in this case?
That George Floyd was a drug-induced, penitentiary swollen, frightening monster. That's the concept they want to put in the minds of the jurors, no matter how ridiculous it may sound to us. That's how they portrayed Rodney King, as the drug-induced, PCP crazed, naked pole clamor Superman. And so they had to beat him into submission. Here, seems to be the same route that they are taking, because they know that, as John Barnett and I used to talk about, when you walk into court with a police officer as a criminal defendant, there's one thing about the Constitution that's right in your face, and that is a presumption of innocence. He is presumed innocent in the minds of the American people and in the minds of the jurors, as opposed to when you walk in there with a non-police officer, whether it's a doctor or lawyer or janitor or whomever, you must be guilty. You must be guilty of something. So they start off at a different position here. The dead man is at fault and the bad guy, and the defendant is the good guy. And that's what we got playing out in front of our eyes. Even certain innuendos and gestures of the judge and admonishing the witness on certain time is soaking into this jury that the judge is in here to maintain order and to referee the game, and they must be out of line. And it may not be a big foul, but they're committing fouls. And the judge has got to protect us from those fouls. So all of that All of that sets into the mind of the jury, whether it's subconscious or not. That's why that judge back in Virginia I talked about earlier said, I'm not trying any more black people in my courtroom, as long as these pictures of white men stand on these walls, because there's a subtle planning of inferiority and superiority. It's just common sense. I'm not trying to be no super psychologist. It's just common sense. What's playing on us? And don't be shocked if this jury come out different than what you know and desire and believe should happen.
Attorney Sweeney, we saw this offense using Falander's Castile case, the drug defense, and the police officer was acquitted. Rodney King criminal defendants were acquitted.
Right.
We know what's coming in defense. Their whole defense, they were asking all the experts the same questions. And when I watched it, the defense lawyer apparently used the same script on each witness. And I noticed that he did not use impeachment of the expert. Instead, his cross-examination, the part I saw, focused on the same line of defense. That is, drug usage. Drugs that caused his death. I mean, to me, it was borderline ridiculous in view of what the videotape said, but what are your thoughts, sir?
Yeah, first of all, when this tragic incident happened last year or a year and a half ago, I knew exactly what the defense was going to be. It's like a broken record. It's the same defense used all the time in civil defense of police officers in these positional asphyxia cases. When I say positional asphyxia, when a person is placed in a position where he can't breathe, he dies of asphyxia. It's the same thing. They take a look at the autopsy report, the defense does, and they pretty much make this a medical defense to confuse jurors. They look at the autopsy report and they say, oh, wait a minute, he has hardening of the arteries. Well, I bet you if you cut every person up and look at their arteries over the age of 35 years old, there's some type of buildup in their arteries. They always say that the person would have been dead within a year anyway because he was in that bad health. And then, of course, they blame the victim for his own death because he was on drugs. He chose to use drugs. And in this case, in the Chauvin case, the judge ruled that his prior drug use could come into evidence, and that's why it played out so prominently in the prosecution's case in chief, because they wanted to get it out there before the defense brought it out, so it wouldn't look like the prosecution was hiding anything. That's because the judge ruled that could come in. But it's the same old thing. It's a medical defense. It's used to try to confuse the jurors and convince the jurors this guy was in such poor health that he would have been dead anyway. Here's the bottom line, though. The bottom line is that the poor man was handcuffed. He was handcuffed. He was no threat to anyone. There was no need at that point to use any type of restraint hold on him. And in all the film that I saw, he wasn't resisting arrest like you see a person flailing around and fighting the police. He wasn't doing that. He was complying for the most part. So I think this defense will fail in the end. I hope it does for this nation's sake. But the defense attorney is doing what every defense attorney does in civil and criminal cases involving the police. They demonize, like Milton Grimes so eloquently described, this black prison pumped up, swollen beast who was 6'6" tall and was going to harm this poor white police officer who you see in the courtroom, who looks beatific, this beatific, angelic look of innocence. But the real Derek Chauvin, you saw is that cell phone camera zoomed in on his face. He is a personification of evil. He enjoyed squeezing the life out of that man. And I think the jury is going to see that. I certainly hope for this country's sake that the jury sees that.
Attorney Banks.
Well, I agree with you, Attorney Lee, that this is the most important criminal trial in decades in the United States, and that we've rarely seen officers criminally tried in this way, and much less convicted. We did see recently a 6-year sentence imposed on a Chicago police officer following the death of Laquan McDonald. And the prosecution is putting on a compelling, methodical, comprehensive, and thorough case. What's unusual about this case, in my view, is that we've seen, 11 law enforcement witnesses, and of course, it's not unusual to see the battle of the medical experts, but to see law enforcement official after another state that the force used in this case was deadly and unreasonable, in my opinion, is unprecedented.
I agree with you. One thing that one that's close home to me, some of those experts have testified in some of my trials. And I would find it fascinating when I watch them testify in this trial. Like one of the experts who gave the most salient evidence was Dr. Tobin out of Chicago. I spent 6 hours cross-examining that guy. And so it was fascinating seeing how they presented to him at this trial. But the thing that bothered me in terms of the presentation of evidence in this case is I kept thinking, typically speaking, if you have that many witnesses testifying to this, first the fact witnesses, they call Attorney Banks talked about, they called the fact witness who regurgitated again and again the same story. I was thoroughly impressed with those witnesses and how they were prepared. These perhaps was the most prepared witnesses that I've seen in a major trial. I felt that one of the expert, the police expert, sometime the one from LA, Attorney Sweeney, I thought he was their worst witness because no matter what the defense said, he just went along. And I was troubled by him because even some of the things the defense said that was patently absurd, he went along. Mm. So I was thinking to myself, why did they call that guy? And so I'm not being critical, I just thought that there was a few things that bothered me. And I thought that I probably ended this case with Tobin thing and closed my case out with Tobin because they proved a prima facie case. He went step by step and showed the stages of death in meticulous terms. He talked about when he was trying to grasp the tire, he looked at the hands and said that he was trying to breathe through his hand. And I thought it was some really graphic testimony with Dr. Tobin Gibbs, by the way. And I would have ended the case that day because that was dramatic testimony that proved cause of death, human suffering, and gross dereliction of duty. And that proved, in my mind, the second-degree murder charge.
But
yes, sir.
My concern is that sitting on that jury is just one, at least one, who has the DNA of white America embedded in their soulmate, in their brain, in their conscious, totally. And that is Black people have to be feared. They've been indoctrinated with that. I had a case once, please bear with me, where the mother took her baby, put its head under the back tire and drove over it and crushed its head. The postpartum psychosis case I had in Orange County. She was a white woman. She came home ultimately and told her husband, a black woman stole our baby, kidnapped our baby. She had on a red wig. Police come to the house and they search the neighborhood. They looking for this black woman with the red wig that kidnapped this white baby. And when they go down to the police station, the husband and wife, and the husband look at his wife and say, honey, what happened to our baby? Because he sees blood specks on her white pants. You understand? So I asked my expert in the trial, doctor, can you explain to the jury why Miss Massey said a black woman kidnapped the baby? He said, well, Mr. Grimes, it's not unusual, and it's commonly understood that if you blame a black person for a crime, people will believe it. Don't have to be accurate. People will believe that. So she was, even though she was insane at the time, her defense mechanism kicked in and she told a lie that she thought would be believed. So I've seen it in too many cases, and I've seen a few of these cases in trial. Some people are just not going to convict a police officer. And most of them believe that black people are superiorly dangerous.
Yeah, you know, Milton.
Because of those, go ahead, John, please.
No, you go ahead, Vanita.
Well, I was just going to say that that's why, we're pessimistically optimistic in this case. We went from 8 minutes, 46 seconds until the first time in the trial. We were introduced now to 9 minutes, 29 seconds. And again, what's unique about this case is that witness after witness after witness, the humanization of the neighborhood, the humanization of George Floyd, the preemptive or proactive testimony of George Floyd's girlfriend, where they admitted that they had been suffering from addiction, as so many Americans suffer across the world. I don't know that I've seen a 9-year-old in a criminal case testify. That also shows the trauma on the African American community. I agree with you that in this case, it only takes one juror, and I had some stats on the composition of the jury before, and hopefully you can fill this in, but there are at least 12 individuals that identify as African American on the jury, as well as 2 that identify as multicultural, and I believe 7 identify as white Americans. And I believe the ages range from, and I'll confirm this, between the 30s through the 50s. So what do you think about the composition of the jury?
Hold on 1 second. Hold the thought for 1 second. Let's get one of the calls, because we have a lot of calls online, and then we'll come back to John Sweeney. Okay, producer, let's take one of the callers.
Hello, Brother Nate.
How you doing?
Hello? Oh, Roy, how you doing?
Great.
Can you hear me?
Yes. We're going to do the follow-up of this topic next Saturday, because we may have a verdict by then, but go ahead.
Okay, no problem. And hello to your guests, and great points. Nate, in my years, I was talking with my mother and family members who are attorneys and the jury, and then that one person that holds out, Minnesota, I guess, is a 12-0 state, because you got some states that are 10-2. I thought it was a 10-2, but it's not. That's always been the issue. We just saw a gentleman in Michigan who is suing Hertz that he spent 5 years in prison for a crime he didn't commit because Hertz couldn't get him his rental receipt, but the jury believed he did the crime only from one eyewitness testimony. It just shows from history when you look at case after case after case, the Flowers case. And now look what just happened with Flowers. and all that. And then the gentleman, 44 years in, I think it was North or South Carolina, that just got out and got the 750,000. 44 years. How do you spend 44 years in prison for a crime you don't commit? I mean, it's unbelievable. It's unbelievable. It's easy for juries, especially white juries, because the judge in Kentucky, who they censured for 30 days, he said that. And a black judge. And so it's easy. It's always easy to just make us guilty first and then innocent second. We see that with the Deshaun Watson case. His lawyer was on last night talking about how his reputation would never be done. That's why he won that case. He won that ruling about having the identities of the accusers made public. Deshaun Watson is made public, so they should be made public. There's no, and that was a critical ruling. Matter of fact, I'd like to hear you guys' opinion of that ruling. That was a critical ruling in those accusations against Deshaun Watson down there. The habeas corpus, you should have the right to face your accuser. And hiding behind the veil of John Doe and stuff like that, didn't care. I don't know what happened in Deshaun's case, but I know he's a black man, and I know it's easy for folks to believe he's guilty before innocent. And I thought that was a critical ruling. What did you guys think about that? And thanks for my call.
Well, thank you. Okay, back to Attorney Sweeney, and we'll get to that later, Attorney Sweeney. Go ahead.
Yeah. We were mentioning before the caller the possible prejudice and misconceptions of jurors trying issues with African Americans. It was brought to my attention this week a very, very important case that's going to be heard by the Sixth Circuit Court of Appeals. And in that case, a black man brought an excessive force case against a police officer, and the jury voted against the plaintiff in that case. Well, it came out that the jurors were making wisecracks during deliberation. One white juror called the black attorney the Cosby Show, referring to the Bill Cosby Show of the 80s, which showed African Americans in a positive light, the mother being an attorney, the father being a doctor. We call him the Cosby Show. And then they talked in the jury room about how calm the plaintiff was when he testified. And a white juror said that's because he must have been smoking dope and drinking at trial breaks. Things like that. So now with this Sixth Circuit case, and if something comes out of that, that's going to be very, very important in combating just these things that Milton was talking about, that we're talking about, the possibility of a rogue juror in the Chauvin trial hanging things up. So that's very important, and it's true. It's a real truth that white folks harbor these animosities and these stereotypes against African Americans. All you have to do is look at, and this election has done so much to bring out the truth of this country, this past election. 47% of people voted for Trump. And so about 1 in every 2 are bigots, in my opinion.
Well, now, Attorney Banks, they made a good point about one juror. Now, we know that in Louisiana, one of the problems with the Louisiana jury system is that they could have this 10-2 verdict of guilt and a person be sent to prison. In this state, to my understanding, it required unanimous verdict of all 12 jurors. And the counsel brought up a very salient point that a single juror can result in a mistrial in this case. Right. And I've been thinking about that, and you were talking about jury composition. The case that I've watched thus far proved guilt way beyond a reasonable doubt. It proved guilt to absolute certainty. And here's why I say that. When you have a case whereby you have to allow eyewitness testimony. That's one form of a case. The second is that when you have scientific evidence that's like DNA, say that you had a hair sample at the scene. That's another type of case. Rarely in American jurisprudence have you had a case where every critical aspect of the homicide from start to finish is captured on good videotape. Rarely have you seen that. The autopsy report in this case, from my standpoint, maybe it was some salient evidence, but the idea of putting your knee on someone's neck for a minute could be fatal. 1 minute could kill you. And so I was concerned about that. I'm thinking this is some overwhelming evidence of homicide. I'm not seeing a more compelling case in our jurisprudence. I'm not seeing witnesses that were so prepared that they regurgitated statements that was identical to the video footage. And I have to attribute that to the lawyers doing a lot of preparation. And I suspect that these witnesses probably seen this video probably 10 times. Now we're going to take a short 3-minute break from our local radio station at this time, producer, and then we'll continue on Zoom.
Fee is a law firm located in downtown
Now,
Indianapolis. The law firm focuses on personal injury claims.
We're still streaming live on Zoom and on YouTube. So while we're at this, the caller mentioned the Deshaun Watson case. I've seen some tidbits about the case, but I'm not familiar with that case. You know, it's lawyer filed lawsuit.
I've seen
Says,
some tidbits too, where supposedly they have 15 masseuses who speak in defense of Deshaun Watson, that he doesn't molest, I would assume, that he's proper and that he's respectful. You know, it's a criminal case still under investigation. This young man is fighting for his future. He's entitled to presumption of innocence. So I don't know what to say about the case because I don't know enough facts, Nate. I've been on both sides. Criminal and civil.
Either you, counsel, follow this case?
I haven't followed it closely.
I've not followed the case, but I did this morning watch his lawyer, Rusty Hardin, talk about. He said something I thought was very telling. He invited the news media to investigate the accusers. Now, that's a very aggressive stance, aggressive posture. And I was thinking about that. It's going to be real interesting to see what these women are actually saying, who they are, and what they're doing.
Yeah.
And
but most
I'd like to know how this lawyer was able to recruit all of these women. That's really a fascinating thing as to how he coincidentally got so many women.
Well, let me just say this, that let's watch this closely. Like Milton said, it's a fluid situation. It's evolving every day. But I want to see if he gets the same justice as the owner of the New England Patriots, Robert Kraft, got when he was basically charged with the same thing down in Florida, having sex with a masseuse. And then eventually the case was dropped. And as we know, he's donated heavily to the Republican Party. And it was down in Florida. So let's see if this black man gets the same type of justice. But I agree with you. All of a sudden you have this piling on effect. One person complains, and then all of a sudden there's 15 women who never said anything about Deshaun Watson before this are piling on because, you know, a payday is in the future.
I had this case before in 2000. I tried it in Long Beach, John, and it was dubbed the limousine rapist case. 9 different women over a period of 3 years accused my client, who happened to be a Beverly Hills wealthy person. They accused him of raping them, picking them up at the top bars and clubs in Beverly Hills and Hollywood and driving them in his limo to his home. And there he and his girlfriend would have their way with these women. And the jury came back not guilty on all 9 of those 29 counts of date rape and kidnapping, etc. And it was because of what John said. It was, we were able to bring out of that with the illegal work of an investigator that later spent 16 years in prison for wiretapping his own clients. Petrocani, I don't know if you know that name or not, John. Pelicani, a leading investigator here in LA.
Pelicano.
Yeah, Pelicano, right. He was in that case and had wiretapped the client when he was representing them. But anyway, it's once you get that snowball effect going in the defense, the jury has got to see it, So let's wait till the evidence come in. I don't know what Deshaun did or didn't do.
Well, it's a fascinating case. Back in the 80s, when I did criminal cases, we had some sexual assault, and our clients were acquitted, and it was pretty aggressive allegations. But what happens is that when you have those type of events, it's usually he said, she said, and it then relate to the credibility of the accuser and the defendant. And you got the lawyer, what he's done, to answer Imhotep's question, he has told the media, go out and investigate these accusers.
Right.
Now, this could be really a fascinating process because what do? Do they put them under surveillance? They then send somebody else in there to secretly get a massage and see what these people are doing. It'd be fascinating as to how you defend a case like this, and I'll be interested in watching this case to see how it transforms into adjudication.
I'm all for doing the work that you got to do, but I also look at the other side of how dissuading this is and how detrimental it is for young ladies who got a serious, legit complaint for sexual assault, now sitting back and said, over this weekend, I'm not reporting doo-doo because I don't want the news media putting me in the next 6 o'clock news headline as an accuser. That could happen to me. So it's that's why there are a lot of laws in different states that you cannot, no matter what the lawyer asks the media to do, you cannot use a lot of the sexual history with young ladies. I don't care if they were prostitutes. They got a right to say no. And yeah, I'm a man, but I have daughters and granddaughters. And, we got to protect everybody. We got to protect Deshaun Watson's rights to a fair trial, but we also got to protect our people. So.
Attorney Banks?
I agree with everything that has been said, and turning back to the Chauvin trial, again, what is so unique in this case and unprecedented is the video. It's just compelling evidence. And one of the big questions now is whether Chauvin will testify. And I'm one of the people that says that he has to, although he's going to face grueling cross-examination, and his prior acts, will come into the case. But at this point, I'm thinking that, if I'm his defense attorney, that, he's got to throw himself at the mercy, of the public. He's got to humanize himself, right? What does he have to lose at this point? He's looking at 40 years. And so it'll be interesting to see whether ultimately Chauvin testifies.
Vanita? Vanita, we got dinner. Chauvin will not testify. He will not testify. I guarantee, what?
I was just going to say the same thing, Milton.
Yeah.
I was going to say, Milton, we're criminal defense attorneys, and what they're going to say is there is a reasonable doubt,
Right.
As to what caused the guys that he will not testify.
I won't claim to have studied them, but I've watched them. I know the Rodney King case. None of the officers testified. They went on the PCP craze theory by the video and what everybody else said. That case was so ill prepared, it takes a whole 2 days to explain why I say that, when the DAs didn't even know some of the discovery they had that I got in civil that they had sitting there in boxes next to them in the courtroom. When they decided and agreed to go to Semi Valley, where police go to retire and die, they went there to try the case with saying, oh, I don't care where it goes. They just did not use assertive intelligence in deciding how to handle that case. And they didn't put King on the stand. There was so many mistakes made. I've seen a case here in one of my cases here where the police testified and lied. Well, I'm sorry, strike that. He didn't testify. He told 2 different lies that were provable. He told the sergeant when he came out that, oh, she attacked me with this handcuff on her wrist and she tried to murder me and my partner. A week later, after he searched this woman, he said, oh, she was reaching for a weapon to internal affairs. So he told 2 different lies. The bottom line is the incident was on his camcorder, on his car camera, showing that the woman told the truth. My hands were behind my back. I asked him, what did I blow? And he went, boom, shot her in the head with a JPX pepper spray gun that shoots a jet stream of pepper spray 405 miles an hour, like a gun that shoots a bullet. Nate knows about gunpowder. It shoots a jet stream of pepper spray 23 feet at 405 miles an hour. He shot this woman beside the head for no reason other than she asked him, what did I blow? He had a 380 in one pocket. He had a Glock on his chest pocket, and he had his service gun on his hip. He had 3 guns on him and this JPX, and he lied. In his own video, he lied, and the jury came back hung 10-2 for guilty because 2 people would not convict him in the criminal trial.
Let me tell you, getting back to the Chauvin case, the reason why I don't believe he testified is because this whole defense is based on blue smoke and mirrors. It's a medical defense, and if he testifies, he'll blow that medical defense. They'll be able to cross-examine him. They are going to get up there, stand up when it's their turn to pull on a case, and say no affirmative defense rests, and they will argue that the prosecution hasn't proven this case beyond a reasonable doubt, which is their burden. And they will talk about, they'll put on, they'll have some witnesses, they'll have doctors to support their medical theories and about drugs and everything. But Chauvin will not see the stand, I don't believe, because he would be destroyed on cross-examination.
And that cop didn't testify in the case where I had with the woman was shot, Vanita, with that pepper spray gun. He didn't take the stand because the DA did not present the case in a fashion to make him take the stand.
That I would not bet against you 2 trial lawyers. I'm interested in criminal trial lawyers, and I'm interested in Nate's opinion as well. But it is an issue that I'm sure is being discussed in the war room of the defense, whether or not he should take the stand. Of course, the defense case is no, and I'm sure there is someone in that war room that is advocating that he take the stand just as vehemently as there are attorneys that are advocating that he not take the stand for all the reasons that that John and Milton are asserting.
Here's the trick. He's testifying in his lawyer's cross-examination. His lawyer is telling the story in his cross. That's the tactic that they're using. We teach that tactic at the trial lawyer college. Tell your story in your cross. And they're telling them.
Excellent.
That's the
Excellent
type.
point. And again, the point was made about the prosecution has to prove its case beyond a reasonable doubt. And the way that we'll see the defense advocate their case will not be surprising. And it's what they have to do. They have to create a, quote, reasonable doubt. From my perspective, one of the themes of the case is, and I looked at part of the opening statement, is that you can believe your eyes. The jury can believe the 9-minute, 29-second tape. And I think that, for the last year, we've lived with 8 minutes, 46 seconds. And now that's been expanded, right? I mean, that additional 1 minute, such and such seconds may not matter, if you will. But I think psychologically, it may have an effect that, not just 8 minutes, 46 seconds, but 9 minutes, 29 seconds, so.
Hey, one thing, counsel, one thing that's important, our YouTube brought out a good point. YouTube people want to know, you guys are adamant that he would never take the stand. YouTube people think that, what about calling the other police officers? Why wouldn't he try to call them? Could you address that real quickly? The other police officers that were there that are also indicted,
They're
why wouldn't he
responsible.
be able to call those folks?
Right. They're responsible. They should be charged. They committed the crime. They did not protect and serve as they had a responsibility to do because they were there on the spot.
They may, in fact, be charged with the crime already. They may have been indicted and well should be. And the outcome of this case is going to crystallize some of that. But the question I thought the caller was asking was whether or not they should, quote, be called to the stand. Is that what I heard, Nathaniel, or no?
Yeah, see, I think you're correct that the other officers were indicted for lesser offense, right?
Yeah,
but
and they may cut deals as well.
YouTube people want to know, why wouldn't Chauvin try to call one of those folks to the stand? In my thought process, they can take the Fifth Amendment also. And if they take the Fifth Amendment, they can be compelled to testify in the courtroom.
The prosecution is not going to call them because they probably don't have
the defense. The defense, we were saying.
Well, the defense is not put on their case yet, are they?
No, they have not. But I'm saying that you guys said that it's 0% chance that Chauvin would take the stand.
Yes.
And so the YouTube people saying, if Chauvin's not going to take the stand, why would Chauvin call the other police officers?
Why wouldn't he?
Yes.
Because they're not. They're going to take the Fifth. They got cases pending. They're not going to give their testimony for his case. And no, they're not going to be called because it's just a tactic of the defense. They can't call these guys because they're not going to say anything. And that'll make him look more guilty if they don't say anything and they police officers. So that's why. But I understand the question being asked.
Okay, now.
Because you're searching for the truth and you would think everybody come and tell the truth. Well, it doesn't happen like that. They don't come and tell the truth.
I also wanted to say a little different point, that America and the world is getting a lesson, at least in terms of the testimony of the police officials, many of the police officials, and I want to speak foremost about the testimony in day 6 of, did we go off the air?
Yeah, we're on YouTube, go ahead.
I wanted to talk about day 6, Police Chief Arando's testimony. We're at least hearing about what policing in the United States should look like in terms of the policies and the testimony, and that police officers should serve and protect. They should render aid when a suspect needs assistance, that they're trained in CPR, that there's the talk about the critical decision-making process, that they should de-escalate, that their training doesn't include putting knees on necks. And so we're hearing a lot, and I hope that police departments across the nation are at least taking note, if they don't already have, some of the policies that are being discussed during the trial. And the orientation and mindset and type of person that's needed to serve our communities, as was articulated and embodied so well by Police Chief Madaria Arando, and I hope I'm pronouncing his name correctly.
Vanita, I spoke earlier and you asked me about it, if I may, Nate. Last night I attended Crenshaw High School football game, and I teased one of the two police officers that were standing near me. I said, man, we just scored when you guys weren't here. Why don't you leave again? Because they had taken a break, right? And so he laughed and we started talking for the next half hour. And it turns out that he is he's an anesthesiologist at Cedars-Sinai, and he's only a volunteer police officer for the last 4 years without getting paid. But he said, well, what do you think about the George Floyd situation? So we expressed differences of opinion. And so he said, well, Milton, do you really think he intended to kill him? He said, I can see that he may have held him in that position and there was no danger. But do you really think he intended to kill him and that he should be found guilty of murder? It's more like, based upon the facts as I see them, manslaughter, and maybe even involuntary manslaughter, because there's no express intent to kill him. What he did was dangerous.
Milton, explain how intent can be proved. It can be proved in a couple of different ways.
Yeah, intent can be proved with your act. I mean, if you shoot a gun at somebody's head, well, now you got to really explain why that's not an intent to kill. But if you shoot the gun in their leg and they bleed out because you hit that big jugular down there, that big artery down there, you can argue all day that I didn't shoot to kill. I shot to stop, or I was mad and I wanted to wound him. So you can fight that all day. So it's hard to prove intent to kill unless the person speak it out or the act is so totally seen as an act that will kill that you can't refute it.
So then you believe the case is properly charged, the second degree, third degree, and manslaughter?
Vanita, I'm not saying what my belief is. I'm just telling you how this officer is looking at it.
Well, Milton, let me tell you something as to, I'm not a prosecutor, but I do plaintiff cases. If I was trying to prove intent, there's something that I'm not seeing them produce yet that I think is salient to that issue, if you think it's important. That is, what about the people that he worked with on a regular basis? I was wondering why they did not call one of those officers to say that he always talked about kicking people, I think he was overtly aggressive.
That's circumstantial evidence, and circumstantial evidence, you can pull it from anywhere to show that his state of mind was to kill at that time, if you got that, Nate. But I don't know all of the circumstantial evidence that exists to show his true state of mind. Or was he just overcome by the situation, by Floyd's resistance, by the crowd threatening that to us wasn't threatening? It was just pleading, begging for this man's life. But to him, it was, it wasn't. I got this picture on my wall of a village shall raise a child. To him, it was the whole village of Negroes out there. It was 100 of them, but it was only 10, But in his frightened, scared mind, I got to maintain this position right now, because if I don't, they're going to overcome me, and I got to figure this out. And time passes like in war or in combat. 2 minutes pass like 2 hours, or 2 hours pass like 2 minutes. There's no reference to true time in a panic situation or a heated moment. I'm just giving you their argument, guys. I'll refrain from commenting, but that's what they're going to fight.
Brilliant deduction.
That's where they're coming from. Attorney
Sweeney, go ahead.
I was saying that Mr. Grimes is absolutely correct. That's what they're trying to convince this jury of.
Yeah.
They're they're trying to brainwash them within a period of about 3 weeks. They got them there, and they're trying to convince them that Chauvin may have gone overboard a little bit, but number one, the guy killed himself because he was on drugs. He has a history of drugs. And number two, they were called out there because he was committing a crime. And then he resisted and he put himself in the position. And how can you blame the police officer? That's what they're trying to show. They're trying to brainwash him within this short 3-week trial. And that's their strategy.
Go ahead, Attorney Banks.
No, I wasn't. Go ahead, Attorney.
Okay, my thought process, I've watched the way that they were doing their narratives on cross-examination. My only comment about that is, in terms of preparation of the witnesses, Dr. Tobin really fought back, and each time he tried to box him in terms of agreement to a salient issue, he fought back and diffused that. The expert from LA, the police expert, I thought did the worst job because he agreed with salient point that really was off point. Like, would you be distracted by the crowd? Well, there's distraction and there's distraction. The fact that it's saying, please don't kill this guy, that's one type of distraction. Another distraction is that somebody throwing a bottle at you or taking a brick to hit you in your head. And so my thought process is that when the police expert testified, he made no effort to explain his agreement. And I just thought that was a mistake. Now, the issue about unanimous verdicts, I believe that a defendant should have a jury decide a case by unanimous verdict. I think that's important to American democracy. But in this case here, I've seen compelling, overwhelming evidence of guilt to second-degree murder. I think that when one thing that stood out in the case to me that really bothered me the first time I saw the video, about 6 minutes into the videotape, Chauvin put his hand in his right pocket and pushed down harder on the guy's neck. And that moment in time, to me, proved intent to murder, because he put his hand inside his pocket and pushed harder on the guy's neck.
Well,
I think that physical things that you do, like what Milton said, shooting a gun, that's the same thing to me. At least I would argue that in closing.
When somebody else is going to argue that was a frustrating act on his part and not an intent to apply more pressure. I'm just telling you that's the immediate rebut to that.
Yeah, but I think that he was intending to inflict pain. I think this is second-degree murder, like you do, Nathaniel. It's going to be hard-pressed for them to get a verdict of first-degree murder.
But you're going to have to show malice for second degree, right? You don't have to show specific intent, but you have to show malice.
Yeah, you have to show malice, and clearly he was trying to inflict pain. That shows malice.
He's going to say that if he was trying to inflict pain, he would have been doing that. He's trying to subdue this overpowerful man. He didn't stop when you have the privilege of stopping from your living room couch looking at TV. That wasn't his situation. He was there in the moment with this drug-induced, penitentiary swollen, unusually large black man.
He was cuffed.
He was cuffed, but he still is a dangerous individual.
With his hand in his back.
I love you, John. I hear you, John. I hear you. Here's what I believe is coming out of this, if I may be so. This headline right here talks about Bruce Beach. They got an issue going now to return property that was taken from black people at the beach out here. I mean, this case is bringing this stuff to the surface, and it's boiling over in different aspects of our lives. They got another picture in here of these elderly white women who have formed a group against racism.
I read that also.
See that picture? They are saying, we gotta stop this. So they're coming out to do something. That's one of the.
It's not just this case, it's the last 4 years of that former president that has caused this backlash.
Right, it's the total of all of it.
One thing, ladies and gentlemen of our local radio show, at this time, our local radio show will end. We will continue this discussion next week on 1310 and 92.7. But also, you can also join us on Facebook Live, also YouTube. Just click over to our YouTube video and you can hear the rest of our program. Thank you. And I look forward to the radio people next Saturday when we continue this discussion. Now, back to our discussion. We have a few more minutes on YouTube. My thought process is that I was hoping that this was a 2-week trial. I thought that there was some compelling evidence, and quite frankly, it just wore me out. You know, it's so painful to watch at times.
Yes.
When they go through these video footage, I was thinking to myself, everybody in this town, including babies, must have cell phone with video cameras. I've never seen anything like this. You know, you have 9-year-olds videotaping a murder. Think about that. I mean, in terms of evidence,
Nate,
in American history, have you seen a trial with so many videos?
Nate, I can't complain about that. You know, the Rodney King case, I said, oh, we finally discovered the Loch Ness Monster because of this man's video camera from across the street. And so now we have discovered the alien invasion, that other mythology in our civilization. We finally caught the alien with the George Floyd killing and the police actually taking 9 minutes and 29 seconds. So we got all of these monsters now, these myths. I don't think we're going to change the social makeup of our country so fast, though. But it helps. And I'm glad for these videos.
Closing comment, Attorney Sweeney.
What's that?
Closing comment?
Yeah, I think this trial crystallizes the problem with race in America in so many ways. Violence against Black people, the fact that a dead Black person is hard pressed, and even a live Black person is hard pressed to get justice in our system of things. And I just hope that I am proven wrong in this case. And I hope that this Chauvin is convicted and sentenced to a long term in prison, because if he isn't, it's going to it's going to widen the gap between African Americans and whites, and it's going to foster more distrust of the criminal justice system by African Americans, which we know is unfair. So this is an extremely important case for this country, not just for the family of George Floyd. It transcends Minneapolis. It transcends the family of George Floyd. It's an extremely important case for this country for the foregoing reasons.
Attorney Banks, closing comments.
I believe that America is on trial. I believe in this case. I believe that the world is watching. I believe that this is a pivotal moment in our history. I believe the video tapes, and I hope that the jury will as well. And I look forward to continuing to discuss this case next week.
The American justice system, there's a truism that we all adhere to. In America, justice requires accountability. Human beings or actors must be held responsible for their misconduct. Without holding people accountable for misconduct, we have no system of justice. what we have is chaos. So we hope and pray that the defendant, based on clear evidence, be held accountable for his action. I thank you for joining us, and please join us next week when we continue our discussion on this important issue. Thank you. May God bless you and stay safe. And also, don't forget, I encourage each and every one of you to take your vaccine because the studies show that the people that have taken the shots, they're not dying, it's saving lives. So thank you. May God bless each and every one of you. Stay safe.